Welcome and thank you for joining Seyfarth's webinar, California Wage and Hour Class Action Litigation, Key Recent Developments and Trends. All participants are in listen-only mode. If you have any questions throughout the program, please use the Q&A feature located on the right side of your webinar window. We will do our best to get to questions at the end of the presentation. If we don't have time to answer questions, then we will send responses via email. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. CLE credit submission instructions, the presentation recordings, and the slide deck will be distributed to attendees via email in the following days. At this time, I would like to turn the program over to our first presenter, Christopher Crossman.
All right, hello. My name is Chris Crossman, and I will be starting us off in the webinar today. But first, we have to show you this disclaimer. All right, everyone got it? Good. Your presenters today are Michael Lafar, Chris Crossman, which is me, and Bailey Byfoss. You should feel free to call or email us with any questions that you may have, either regarding this presentation or any other labor and employment issues that you may want to discuss. Now, we have many exciting developments to cover today, but first, we wanted to let you know that Seyfarth Shaw has just released the 23rd edition of the leading publication in the field, Litigating California Wage and Hour Class and PAGA Actions. It's been updated with many recent major legal developments, and we'll be reviewing a number of them today, of course. The agenda for today includes recent trends affecting Private Attorneys General Act representative actions, the impact of arbitration agreements on class and PAGA actions, the latest decisions involving service charges, gratuities, and the regular rate of pay, and a peek at the key cases that the California Supreme Court is currently considering. Unfortunately, many of these recent legal developments are not that favorable for employers, but don't worry, we, your friends at Seyfarth, are here to help you navigate your way through these treacherous waters. All right, so as I mentioned, the 23rd edition of Seyfarth Shaw's California Wage and Hour Class Action book has just come out. And yes, that's true. We've been publishing this book since back in the day when folks were celebrating the dawning of the new millennium. And children who were born when this book first came out have now graduated from college, if you can believe it. So there really are decades worth of defense-oriented legal analysis and advice packed into this one volume. Now, here we show you the cover of the current edition in a beautiful eye-catching burnt orange. For some of us, this takes us back to the mid-70s. The book is free and available in a handy ebook format. We will tell you how you can get your own copy at the end of the webinar. Now, this book covers a veritable plethora of key issues facing California employers in connection with wage and hour litigation, from expense reimbursement to meal and rest claims, to unfair competition claims, CAFA removals, class certification, discovery issues, class action waivers and arbitration, and settlements of class actions, all from a defense perspective, including strategy pointers and the case citations that you need to make winning defense arguments. This year, we've added 2 new chapters. The first one focuses on joint employer liability. And joint employment often arises as an issue in the context of employees sourced through employment agencies. And this issue also frequently is present when an employee sues not only their direct employer, but also other affiliated companies. The other new chapter in this year's edition focuses on the regular rate of pay, which is one of the most common sources of liability in connection with California wage and hour class and PAGA actions today. I have to tell you that personally, I had very few of these cases 5 years ago. Today, every single class and PAGA action that I see come across my desk has a regular rate of pay claim. These claims are one of the most difficult things for employers to get right. And if you are an employer with lots of non-exempt employees in California, you should definitely have your legal counsel conduct a payroll audit to ensure that you are properly factoring in all necessary types of compensation into the regular rate of pay and that you are properly calculating it once you factor it in. This can help you avoid literally millions of dollars in potential liability. In addition, our book has a handy statute of limitations reference section to help you keep track of the differing time periods applicable to various types of claims, as well as a table of cases and an index of key terms to make it that much easier to find what you're looking for. Okay, now on to the recent legal developments and trends. First, we're going to cover developments affecting representative actions under the Private Attorneys General Act. So first, it's important to recognize just how prevalent PAGA litigation is becoming. About 10 years or so ago, it was quite common for PAGA claims to be added on to class action lawsuits almost as an afterthought. Nowadays, more and more PAGA actions are being instituted. As you can see, the number of pre-litigation PAGA letters has gone up about 400% in the last 10 years, and a record number of those letters was sent last year. Nowadays, many PAGA claims are filed as standalone lawsuits without a companion class action being asserted at all. Now, there are many reasons for the increased popularity of PAGA actions. First, plaintiffs do not have to meet class certification requirements in order to represent a group of employees. Penalties can be recovered for violations of nearly every labor code section, even ones for which there is no private right of action. A single violation, such as an underpayment of wages, can result in potential exposure on derivative claims, meaning multiple penalties can potentially be stacked one on top of the other based on the same conduct. Of course, PAGA provides for the recovery of attorney's fees by a prevailing plaintiff, which, as we all probably know, is the reason why most PAGA claims are filed in the first place. I have yet to see a plaintiff who walked into an attorney's office saying, "I'm desperate to file a Private Attorneys General Act claim." Usually, it's the attorneys who are driving these lawsuits. Now, unlike class actions, PAGA claims cannot be waived by employee arbitration agreements. And also, because the amount in controversy of the group of aggrieved employees in a PAGA action cannot be aggregated for removal purposes, it is extremely difficult to remove a PAGA-only action to the more employer-friendly confines of federal court. Now, there is some hope for employers on the PAGA front. There's a ballot initiative to repeal PAGA that is going to be included on the November 2024 election. And if successful, this initiative would replace PAGA with a new law called the Fair Pay and Employer Accountability Act. Under this new act, employees would receive 100% of any recovery, rather than the 25% that they currently receive under PAGA. And as you probably know, the other 75% currently goes to the state of California. Under the new act, statutory and civil penalties would be double what they currently are under PAGA. However, penalties would be available only in connection with willful violations. So no more gotcha violations where employers thought they were following the law, but suddenly a ruling comes down from the California Supreme Court that changes what everyone thought was the correct way to proceed. The Act provides a mechanism for employers to obtain advisory opinions from the Labor Commissioner regarding ambiguous relations, and we know there are quite a few of those. And instead of employees filing claims in court, they would be heard in an administrative proceeding before the Labor Commissioner. However, most importantly, under the new Act, attorneys' fees would not be recoverable. And this is critical because plaintiffs' counsel, as I mentioned, are the driving force behind nearly all PAGA actions. And the reason for this is because they stand to recover large amounts of attorney's fees, even though the aggrieved employees typically recover very little. It's unclear whether the Fair Pay and Employer Accountability Acts will stand a chance of passage in November. The well-funded plaintiffs' bar is sure to pour tens of millions of dollars into advertising against the bill. So I guess the message is get out there and vote. Okay, now on to the legal developments. One of the most important recent decisions affecting PAGA was handed down by the California Supreme Court this past January. In Estrada versus Royalty Carpet Mills, the court held that trial courts may not dismiss PAGA claims solely because they find them to be unmanageable. Now, previously, several Court of Appeals decisions had ruled that judges could dismiss PAGA claims under such circumstances, and this was one of the key tools in the defense bar's belt in attacking broad PAGA claims. Now, obviously, Estrada is not a great decision for employers, but on closer inspection, it's not really as bad as it might first seem. The Supreme Court did note that trial courts can limit the scope of PAGA claims and can limit the type of evidence that can be presented based on manageability concerns. So, although they can't dismiss the claims, they can limit them. The court also said that trial courts can issue rulings on demurrer or summary judgment to manage overbroad or unspecific claims where the plaintiff cannot prove liability as to all or most employees. Also, the court reaffirmed that employers have due process rights to present affirmative defenses. Accordingly, an employer must still be permitted to introduce its own evidence, both to challenge the plaintiff showing and to reduce overall damages. And if plaintiffs seek to use a statistical model to prove their claims, defendants must be given a chance to impeach that model or otherwise show that its liability is reduced. The Supreme Court explicitly left open the question of whether PAGA claims could be struck to preserve an employer's due process rights. So that issue remains to be decided. Now, in the wake of Estrada, employers should push for trial courts to use the case management tools that the Supreme Court affirmed that they can employ to efficiently manage trials of PAGA claims. And in doing so, employers should continue to advocate for trial courts to require plaintiffs to provide trial plans. And this is critical. Bring it up at the very first case management conference if you're presented with an overbroad and unmanageable PAGA claim, and keep bringing it up at every conference thereafter. Also, employers should hold plaintiffs' feet to the fire and require that they use sound statistical sampling methodologies to demonstrate that any trial of PAGA claims can be effectively managed while preserving the due process rights of the employer to present its defenses. The Supreme Court's decision still permits trial courts to effectively manage PAGA claims by other means short of striking the claims outright. For example, overbroad and unwieldy PAGA claims can and should be limited in scope via demurrer, motion for summary judgment, and or narrowing down the plaintiff's definition of aggrieved employees. Indeed, the Supreme Court reaffirmed that trial courts can limit the evidence to be presented at trial, which could reduce the group of aggrieved employees as to whom claims are being adjudicated. Our next development, Woods versus Kaiser, concerns whether an employee may institute a PAGA action in connection with violations of California's sick pay statute. California's Healthy Workplaces, Healthy Families Act of 2014, as set forth in Labor Code Section 245 et sec, generally requires that employers provide employees with at least 3 paid sick days per year. Now, of course, there are local variations on this, so depending on your city, you may have to provide more sick pay. In Woods, a former employee brought a claim on behalf of herself and other employees for civil penalties, alleging that her employer had failed to pay sick leave at the correct rate. The employer pointed out that the statute contained an express limitation on actions seeking to enforce it. The employer, in fact, pointed that Section 248.5 of the Labor Code authorizes only the Labor Commissioner and Attorney General to collect penalties, while the remedies for an individual plaintiff are limited to, quote, equitable, injunctive, or restitutionary relief, end quote. And based on this language, a number of federal courts and state trial courts had previously held that the law expressly prohibits a private plaintiff from recovering PAGA penalties. Based on this language, the trial court here also granted the employer's demurrer without leave to amend. However, unfortunately, the Court of Appeal reversed. While the court agreed that an employee cannot file an individual action for violations of the Healthy Workplaces, Healthy Families Act, this does not mean that the legislature also intended to preclude a PAGA action based on the same alleged violation. The court stated that, quote, PAGA is not a private right of action, but rather a procedural device under which an agent or proxy of the state enforces the government's ability to collect penalties, end quote. The court went on to state that while a PAGA action is brought on behalf of the public, who acts as an agent of the state, from the legislature's perspective, a PAGA claim is not brought on behalf of the public, but instead on behalf of other aggrieved employees. The court also found that the language in the act limiting the remedies for an individual plaintiff to equitable, injunctive, or restitutionary relief was meant to refer to claims brought under the unfair competition law and not PAGA. So now, unfortunately, employers have yet another type of PAGA claim to be on the lookout for, namely those based on alleged violations of the sick leave statute. However, if you're defending such a claim in federal court, note that those judges are not required to follow precedent from a state's intermediate appellate court if they find convincing evidence that the state Supreme Court likely would not follow it. And moreover, one California Court of Appeal district decision is not binding on another district or on a different panel of justices within the same district, and there is likely to be further legal development in this area in the near future. All right, next up is Howitson versus Evans Hotels. There, the plaintiff filed a putative wage and hour class action against her former employer, and she then accepted an offer to compromise that called for entry of judgment in her favor in her individual capacity. Following the entry of this judgment, the plaintiff then filed a PAGA action based on the same facts as her prior lawsuit. Now, the employer argued that claim preclusion, which is also known as res judicata, barred the plaintiff's PAGA claim because the claim was based on labor code violations that she could have asserted in the first lawsuit. And the trial court agreed, sustaining the employer's demurrer without leave to amend. The Court of Appeal, however, reversed, holding that the requirements for claim preclusion were not met in this case. The court arrived at this conclusion primarily because the two actions involved different claims for different harms, with the first action involving claims for harms to the plaintiff, while the second involved harms to the state and the general public, and also because the state, which is the real party in interest in a representative PAGA action, was neither a party to the prior action, nor was it in privity with the employee. Now, this holding is not terribly surprising, considering that the California Supreme Court had previously held in Kim versus Raines that an individual who settled their underlying labor code claims still had standing to pursue a representative PAGA action based on those same claims. Next up, we have Clark versus QG Printing. Now, while this is an unpublished district court opinion, it demonstrates an important difference that arises when litigating PAGA claims in federal court as opposed to state court. In Clark, the plaintiff did not submit his pre-litigation PAGA letter to the LWDA until more than a year after his employment with the defendant had ended. The employer sought summary judgment, arguing that the plaintiff lacked standing to pursue a representative PAGA action on behalf of other employees, because his own claim was barred by the statute of limitations. The plaintiff asserted that he did have standing, pointing to a 2021 decision by the California Court of Appeal, Johnson versus Maxim Healthcare. And Johnson had held that an employee whose individual claim against the employer is time barred could still pursue representative PAGA claims. One of the worst decisions, in my view, out of the Court of Appeal in recent years. However, the district court here disagreed, noting that in federal court, a plaintiff must demonstrate that they have Article III standing. In general, for a party to establish Article III standing, he must allege and ultimately prove that he has a genuine stake in the outcome of the case, because he has personally suffered or will imminently suffer, 1, a concrete and particularized injury, 2, that is traceable to the allegedly unlawful actions of the opposing party, and 3, that is redressable by a favorable judicial decision. Because the plaintiff in the Clark case could not demonstrate that he had suffered any injury that he could recover for in connection with his PAGA action, therefore the trial court found that he lacked Article III standing. So this case is a good example of an advantage that employers have when defending PAGA claims in federal court, although unfortunately it does not apply in state court. Finally, we have Shaw versus Superior Court. There, the California Court of Appeal provided some relief to employers who face multiple overlapping PAGA actions. In Shaw, the employer was hit with 2 separate PAGA representative actions that included many of the same claims. The second action, which was filed by plaintiff Shaw, contained claims that were all included in an earlier lawsuit. The trial court stayed the second PAGA action pursuant to the exclusive concurrent jurisdiction doctrine, which provides that where 2 or more courts possess concurrent subject matter jurisdiction over a cause, the court that first asserts jurisdiction assumes it to the exclusion of all other courts. On appeal, the Court of Appeal agreed that the exclusive concurrent jurisdiction rule can apply where 2 PAGA actions simultaneously seek similar relief. In doing so, it held that the trial court did not abuse its discretion in staying a later filed PAGA action because it could reasonably conclude that allowing both actions to proceed, quote, would duplicate court efforts, waste resources, and potentially produce divergent results, precisely what the exclusive concurrent jurisdiction rule is intended to present. So this case is good news for employers who will now have more assurance that they are protected against litigating duplicative PAGA lawsuits at the same time. All right, next, I'm going to turn it over to Michael Lafar, who will discuss the impact of arbitration agreements on class and PAGA actions. Michael?
Thanks, Chris, and thank you everybody for joining us today. It's nice to see some familiar names on the attendee list. If we go to the next slide, please, Brenda. So to start off with the arbitration discussion, it's become very important, given the rise of class actions and PAGA actions, that clients have enforceable arbitration agreements, not just as a way of wholesale getting rid of some of these claims, such as with a class action waiver, but also now with the state of the rise of PAGA actions to create some additional measures to defend themselves with these types of claims. So I won't rehash Adolph in complete detail because I'm sure you've thought way too much about it over the last year. But as a brief refresher, Adolph was a case that came out last year from the California Supreme Court that directly rejected the U.S. Supreme Court's take on PAGA waivers in arbitration agreements in the Viking River decision. And the key holding from the Adolph decision was that a plaintiff whose individual PAGA claims are compelled to arbitration still retains standing to pursue those representative PAGA claims in court, while their individual claims can be still compelled to arbitration. And the court made it very clear that the outcome of that individual arbitration can be binding on issues of standing as to the larger representative action claims. In other words, if the PAGA plaintiff prevails in arbitration, the individual arbitration, even on just one claim at all, then they'll still have standing to pursue the broader PAGA claims in court. But if the employer can prevail on everything in individual arbitration, then that should be enough to extinguish standing on the representative PAGA claims. Next slide, please. And so one of the things we are constantly talking to clients about is how good is your arbitration agreement? And in particular, do you have the language that you need, not just from a class action waiver, but more importantly now from the PAGA waiver? And so following those two decisions in Viking River and Adolph, the particular language we're looking at is whether you have the key words about an individual PAGA claim and what can be compelled to arbitration and what can't. And so you'll see on the slide that there is there's no one-size-fits-all right type of language, but you'll see an example of some type of language that we've had success with in other cases where courts have held that these types of cases can be compelled to individual arbitration and that language is sufficient. Next slide, please. And so the main question is, why does it still matter? With the rise of these types of cases, a lot of clients are looking at compelling individual arbitration and trying to see if they can cut off the head of the dragon, so to speak. If they can prevail in the individual arbitration, then it's one other defense mechanism that they have to try to get rid of the broader PAGA claims. And courts are still, even though it's been a year, even though employers have consistently been enforcing their arbitration agreements or rolling out new ones or updating it over the last year, you're still seeing decisions come out from the California Courts of Appeal or the Ninth Circuit where there is still some hostility to poorly crafted class and PAGA waiver language in arbitration agreements. And so one recent example is a case called Hasty v. AAA, or the American Automobile Association, and that's a decision from late last year that was just recently published. And so there, what you had was arbitration language where the particular language said that the individual will agree to arbitrate all of their individual claims, but also said that they agree to not bring any claims or that they waive all of their claims brought on a private attorney general basis. The particular language in the agreement didn't specify between individual private attorney general claims and representative private attorney general claims, which is a little bit of a legal fiction, but nevertheless, it's something that the Court of Appeal focused on here and said that the requirement that an employee's claims be brought solely in an individual capacity and not in a private attorney general capacity precludes the employee from bringing a claim under the act in arbitration or in court, and that the California Supreme Court in Adolph said that, and in Iskanian said that that type of language is not enforceable and that you cannot waive your right to bring a claim under that act. And so, a lot of employers have looked at their arbitration agreements and have thought that the language is correct, and this is a good refresher and a good point for everybody to go back and look at their arbitration agreements to see if they have the type of language that will be defensible, whether there's anything that needs to change, or to have an outside attorney review it and to make recommendations about ways that that can be revised. Next slide, please. One of the other things that we're seeing, particularly with the class and PAGA cases, is modifying your arbitration agreements to benefit the company with respect to the individual proceedings and obtaining a stay of the representative PAGA proceedings so that you're not dealing with multifaceted or two-front litigation. There was a bill that just went into effect at the beginning of this year that eliminated a rule from the United States Supreme Court in a decision called Coinbase that automatically stayed all trial court proceedings pending the appeal of a denial on a motion to compel arbitration. And what this means is that ordinarily, if you lost on a motion to compel arbitration, the underlying proceedings would be stayed while you went through the appeal. That's no longer a mandatory rule in California. It still is an option. It'll be discretionary as to each particular trial court, but what it's emphasized is that it's another thing to look at in your arbitration agreements to try and incorporate mandatory stay language so that if you do run into this type of situation, hopefully the trial court will feel obligated to follow that particular language. Next slide, please. In addition, we're looking at arbitration agreements to stay the representative action claims so that while the individual arbitration is proceeding, there is not going to be that dual-face litigation with a representative PAGA claim going on at the same time. That's one of the benefits of having an arbitration agreement. Even if it's not able to outright get rid of the PAGA claim altogether, it can at least temporarily pause an employer's need to gather information or provide documents or go through discovery on a much more burdensome PAGA case as opposed to dealing with a single individual in a relatively expedited individual arbitration proceeding. And so the language of the California Code of Civil Procedure in 1281.4 says that the court shall stay any action until the arbitration is completed. And the California Supreme Court in the Adolph case recently confirmed that the individual PAGA claims in arbitration, as well as the broader representative PAGA claims, are part of a single action or proceeding, so that if the individual case has to go to individual arbitration, then the rest of the case should be stayed. Unsurprisingly, the California Supreme Court danced around this particular language a little bit and was not as clear-cut in its decision that it should be a mandatory stay as opposed to a permissive stay. But we've seen language in other Court of Appeal decisions, including one in Gregg v. Uber Technologies from last year, where the particular arbitration agreement had language mandating a stay while the individual action was underway in arbitration. And so to the extent you are looking at revising your arbitration agreements or rolling out a new one now, this is another type of clause that we would recommend including so that you're not faced with dual front litigation. Next slide, please. I'll toss it over to Bailey to talk a little bit about some recent decisions from the Ninth Circuit, and I see we have a question on it, including the Ortiz matter about the FAA and transportation worker exemptions.
Amazing. Thank you, Michael, and thank you, everybody, for being here. Yeah, so some of you might be aware of the fact that the Federal Arbitration Act, the FAA, has an exemption for transportation workers who are engaged in interstate commerce. What is a transportation worker under this exemption? I mean, typically you think of folks like railway operators or long-haul truckers, folks that are actually crossing state lines as part of their job duties. Those folks are engaged in interstate commerce, and there's an exemption under the FAA for those folks, so they're not covered by the FAA. Now, what we're seeing is a little bit of a trend that I would call perhaps troubling in the last year from the Ninth Circuit here. One of the first cases that we saw on this was Carmona Mendoza versus Domino's. You see that referenced here on the slide. And what this case involved, not your pizza delivery drivers, not those folks, but people who were driving the raw pizza ingredients from a Domino's warehouse in the state of California to the Domino's franchises that were in the state of California. So they're the folks taking your flour, your pepperoni, your mushrooms, your whatever you want to have on your pizza. They're taking that from the California Domino's warehouse to the California Domino's franchises. And the Ninth Circuit looked at that and said, those folks are engaged in interstate commerce. And it doesn't matter that their only transit is within the state of California, because what they're doing is they're picking up goods that have come from outside of the state, and they're carrying them sort of further on their interstate path. So those folks are engaged in interstate commerce, and those folks are going to be exempt from the FAA. We had another similar case come out, in fact, exactly a week ago, Ortiz. In this case, the Ninth Circuit took us a step further and said that this gentleman who was working in a warehouse, moving goods about within that warehouse, was similarly engaged in interstate commerce. Same argument. Those goods are coming from outside the state, they're passing through the warehouse, and then they are leaving the warehouse and continuing on their journey, be it to somewhere else in California or outside the state of California. That person, that warehouse worker who is engaged with those goods within the confines of the warehouse, is part of the interstate journey that those goods are taking, and therefore that person is engaged in interstate commerce, according to the Ninth Circuit. Why does this matter? You have heard us for years talking about the ways in which California has tried to attack arbitration agreements and the validity of arbitration agreements. And time again, what we're hearing from the United States Supreme Court is California, that doesn't fly because it's preempted by the FAA. Why can you not have class action waivers in arbitration agreements? Because they're preempted by the FAA. Similar result with respect to PAGA representative action waivers. Similar result with respect to AB 51. Some of you might recall our discussion on that over the last couple of years with respect to the enforcement of mandatory arbitration agreements. All of those things preempted by the FAA. What happens when you have a group of workers that is not covered by the FAA? There's some risk with respect to these folks. So this is a trend in the case law that we are currently keeping a very close eye on to see how it develops. I'm going to talk a little bit more about many of the cases that are pending before the California Supreme Court this year and kind of stuff that we're watching for in 2024. But first, Michael is going to talk to you a little bit more about service charges, gratuities, and the regular rate of pay.
Thanks, Bailey. So this is an issue that's been extremely hot over the last year and has been picking up a lot of steam as of late. And so if we can go to the next slide, you're probably wondering, or you've seen this language, whether in your own day-to-day life or whether it's part of your particular business. It's hot in hospitality and food service, in retail, even in travel or banking. You'll see language talking about tips or gratuities or service charges, something that's mandatory versus not mandatory. And while many of us have never really thought twice about it, it can be very important and very costly potentially from a legal perspective because of California Labor Code Section 351. And that particular section says that an employer is forbidden from taking any part of a gratuity or effectively a similar type of payment that is left for an employee by a patron, or to require an employee to credit that amount of the gratuity against their wages, and that every gratuity is the sole property of the employee for whom it was left. And so you look at what in practice is the real effect of something like this, and what are the differences between how California treats service charges versus a tip. At its core, it goes back to what Chris mentioned at the beginning of the slides and at the beginning of the presentation, which is the regular rate of pay. The service charge is something that needs to be included in the regular rate of pay, whereas just giving an employee a cash tip is not included in the regular rate of pay. And for California in particular, a failure to include particular types of payments in the overall compensation, in the regular rate of pay calculation, can be the difference between owing just a few dollars and the difference between your meal and rest period premium payments being incorrect, between your sick pay calculations being incorrect, between your overtime calculations being incorrect, between having to pay waiting time penalties potentially, or having wage statements that are incorrect. It triggers an avalanche of other derivative claims just because of a failure to treat a particular type of payment as a service charge versus a tip. And if we can go to the next slide, it all started with a case called O'Grady v. Merchant Exchange. This is a case from 2019. And leading up to the O'Grady decision, effectively, employers could call anything a service charge. And the prior case law said that because you labeled it as a service charge, that was never a gratuity. That position was rejected by the California Court of Appeal, said that the service charge is a vague term, and it rejected that argument that just because we call it or we assert this label of a service charge that it can no longer be a gratuity. And that instead, you have to look at what did the customer intend for that payment to be. If it's a mandatory 18% service charge that you added to a banquet event or to a party of 6 or more, did the customers think that that was intended to go to the employees effectively as a gratuity? Or did they understand that all or a part of it was going to go to the employer, whether it's a hotel or whether it's a restaurant, things like that? And the reason it makes a difference is because typically a lot of language on employer service charges was not clear or never had to be clear about what the allocation was. So for example, in a banquet context, if you're applying a mandatory 25% service charge and you don't explain that a portion of this is going to employees and a portion of it is going to the house or to the employer, and explaining that the portion retained by the employer is not intended to be a gratuity, then there could be some reasonable confusion, or at least a claim brought under that allegation that that amount of money should have actually gone to the employees. And that is the amount of money that would typically be at issue with these types of cases. Next slide, please. The first real case that we had came out last year that touched on this issue, and that's a case called Ordonio v. Marriott. And it was a bench trial, and after a few days, the California Superior Court judge issued an award of $9 million in damages for those unpaid service charges to a group of banquet servers. This is a case that was brought by the Liss Reardon firm. Many of you are familiar with them, not just on the app-based driving type of claims that they bring and the misclassification claims, but they are now pursuing a lot of these claims for service charges. And it's popping up across many different employer groups, including, as I mentioned, the hotels or food industries or restaurants, things like that. In that trial, the court held that the service charge language on things like banquet contracts, receipts, menus, et cetera, did not specify cleanly enough that these gratuities or these service charges were intended to be just a service charge or just a gratuity, or what portion was split. And so when looking at the evidence, including from reasonable customers and going out and getting that discovery, ultimately the court held that it was a gratuity that should have gone to the banquet service staff. And so you're seeing that also in a case later in 2023 where the court denied a motion for summary judgment and saying that these are potentially triable issues. And when you think about what that entails, that could mean the plaintiff going out and getting contact information or seeking to get contact information from your customers and looking at all of your language in your banquet contracts or your service orders or menus or receipts, requiring an employer to retain that type of information, and looking at whether or not an objectively reasonable customer would have understood that mandatory service charge to be such that, or to be potentially a gratuity that should have been paid out to employees. Next slide, please. So the one positive that did come out of the Ordonio case is that there was an order granting summary adjudication to Marriott based on a change in their contract language. And the court held that that language was sufficiently clear enough so that there was no triable issue, that it explained what the service charge allocation was, how much was being retained by the hotel, and how much was going to employees, such that a reasonable customer would have understood it to not be a gratuity or to know what portion was kept by the hotel, and that summary adjudication was warranted. And so you'll see on the screenshot there where it says specifically that the 25% service charge is being allocated into two different buckets, but more importantly, in the bolded language, it says that the house charge is used to offset the cost of utilities and equipment and other non-labor expenses, and that it is not a tip or a gratuity for services provided by employees and is not distributed to employees. And so that's the type of language that employers need to have in all of their documentation so that they could obtain summary judgment or summary adjudication. The tricky part is that these types of claims go back 4 years. They're brought under the unfair competition laws. And so even if you haven't had that type of language, it's important to look at all of your documentation now and see if there are ways that you can modify it going forward so that in the event that you are unfortunately hit with lawsuits or litigation on this issue, that you've cut off potential exposure going forward. Next slide, please. So with that, I'll kick it back to Bailey so she can talk about what to expect coming up in the next year.
Back to me. Brenda, can you go to the next slide, please? All right, so we're going to talk about a couple of cases that are up before the California Supreme Court this year and stuff that we're watching for anywhere from in the next couple of weeks to sometime down the road in 2024. This first case, Quach versus California Commerce Club. I will admit this is not a purely wage and hour case. I debated on whether to include it, but as you have probably gathered from our presentation so far, arbitration agreements are a fairly significant part of our wage and hour practice right now. So this case is directly on point with respect to the way that motions to compel arbitration are going to be decided going forward. And so we wanted to spend a couple of minutes talking about it. Now, brief background. Historically, the question of whether a party has waived its right to compel arbitration in California was decided based on 5 factors from the St. Agnes case that came out in 2003. And the court looked at all of these factors when it was deciding, hey, typically defendant, have you waited too long? Have you waived your right to move to compel arbitration in the particular case that's before us? It's looking at things like whether that party's actions are inconsistent with the right to arbitrate, whether the, quote, litigation machinery has been substantially invoked. And one of the things that it's looking at historically, or that courts have looked at historically, is whether the moving party's conduct has affected, misled, or prejudiced the party that is opposing arbitration. So in an employer-employee situation, employer is moving to compel arbitration of the employee's wage and hour claims. Has the employer's conduct in this litigation so far prejudiced the employee? We had a case come down from the United States Supreme Court in 2022 that said, no, prejudice is not a relevant factor when deciding whether a party has moved to compel arbitration. Typically, when we're looking at whether a waiver of a particular right has occurred, the court focuses on the actions of the person that held that right, not the effects of those actions on the opposing party. So prejudice is not a factor that we're going to consider here. So Quach is expected to clarify whether, following the Morgan versus Sundance case, if prejudice remains a relevant factor in the waiver analysis. What this is just going to mean for California employers is how this question of waiver is going to get decided on a go-forward basis. If you're bringing a motion to compel arbitration and the plaintiff responds by saying, no, they've waived their right to pursue this motion at this point by their conduct, is there a requirement to show that the plaintiff has been prejudiced by the conduct that the employer has engaged in the litigation to date? This one has been fully briefed, no oral argument set yet, so we've got a little bit of time. Brenda, next slide, please. All right, first actual wage and hour case, Huerta versus CSI Electrical Contractors. So Huerta worked for CSI Electrical Contractors on this job site that is a little bit unique. Had one entrance where workers drove up to a security gate where CSI required them to report for duty each day. And at the security gate, the workers had to scan their badges, and then the security guards sometimes looked into their cars. And then they had about a 10 to 15 minute drive from that security gate to the employer's parking lot. During this drive, they were subject to various restrictions, one of which is the Department of Fish and Wildlife was involved with some endangered species on and around the job site. And so there are rules about you can't drive above a particular speed, you can't create dust as you're driving down this road. Sometimes there was a biologist that had to clear the road of animals before workers could drive down the road to get to their work site. No loud music, no smoking, stuff like that. At the end of the day, the workers have to go back through that same exact process. So, and here's where there's a particular thing that I think is going to be helpful context for this. In California, the definition of hours worked is not based purely on when the employee is working. Hours worked in California includes all time during which an employee is subject to the control of the employer and when the employee is suffered or permitted to work, whether or not required to do so. So the question in Huerta was, is this time that the employees spend going from the security gate to the parking lot, is that hours worked? Is that time sufficiently controlled by the employer such that it needs to be considered hours worked in California and it needs to be paid? The trial court granted summary judgment in favor of CSI, finding that this time was not sufficiently controlled for purposes of hours worked, for purposes of minimum wage within California. Next slide, please. That went up to the Ninth Circuit, who decided to certify 3 questions to the California Supreme Court. Those questions are here on your screen, but the bottom line associated with all of them is the Ninth Circuit asked the California Supreme Court to decide, is this hours worked? Within California law, should we consider this time to be hours worked within the meaning of California law? If this feels familiar, it probably should. Some of you will recall the Apple bag check case that we got a couple of years ago. That was subject to exactly the same sort of procedural posture. It was pending in the Ninth Circuit. The Ninth Circuit said to the California Supreme Court, hey, we have a bag check case here. Do you think that bag checks should be considered hours worked for purposes of paying minimum wage under California law? You will remember that the California Supreme Court responded to that question in the affirmative. That is the same procedural posture that we have here. So this is going to be a really interesting one to watch. We know that employees have to be paid minimum wage for all time that they're subject to the employer's control. There's a spectrum of sort of control to no control to most control. Huerta is likely going to give us another data point as to kind of how that spectrum works. We're also going to hear on this one presumably very, very soon. Oral argument was heard on January 4th, which means we should expect a decision from the California Supreme Court by about April 3rd. So pretty soon. Next slide, please, Brenda. Naranjo, is it 2022? What are we even doing here? Yes, Naranjo is back in front of the Supreme Court again. Brief refresher on this one. Naranjo was filed in 2007. That was when this class action complaint first showed up. So this one's been kicking around for a good chunk of time. In 2019, the Court of Appeal gave us a very favorable decision. It affirmed in that case the trial court's finding that Spectrum had violated the meal break clause, okay, but reversed the trial court's holding at the time that said a failure to pay meal break premiums could support claims under the wage statement and waiting time penalty statutes in California. So 2019 Court of Appeal says, yeah, okay, even if you owe meal period premiums, that doesn't trigger waiting time penalties or wage statement violations. In 2022, the California Supreme Court disagreed, said wage statement violations and waiting time penalties do result if break penalties go unpaid. And let me give everybody just a brief refresher on kind of the statutes that we're talking about while we move to the next slide. Because Labor Code Section 226.7 is the one that requires an employer to pay a premium of 1 hour's pay whenever a meal or a rest period is owed and not provided, right? Brenda, can you go to the next slide, please? So 226.7 requires the premiums. 226 is the wage statement statute. Penalties under Section 226 apply when an employer knowingly and intentionally, it's important language, fails to state the gross wages earned by employees on their wage statements. Labor Code Section 203 requires that all wages be paid to employees within a prescribed period of time following their departure. So if you're going to terminate somebody, you have to pay them all of their outstanding wages immediately. And if an employer willfully pays such wages, or willfully fails to pay such wages, waiting time penalties apply. The existence of a good faith dispute precludes a finding of willfulness. So a good faith dispute does not require a successful defense. It exists unless a defense is unreasonable or unsupported by any evidence. So a reminder that in 2022, the California Supreme Court said, yep, wage statement and waiting time penalties apply if meal break premiums are unpaid. So this case goes back down to the California Court of Appeal, and the California Court of Appeal issues a decision that says, okay, meal period premiums are wages. 226 and 203 penalties can attach if those meal period premiums are not paid timely or as appropriate. But in that case, the defense to 226 and 203 penalties that applies to wages, that also applies to meal period premiums. So if there's a good faith dispute that meal period premiums are owed, then waiting time penalties aren't going to attach to that claim. This has now gone back up to the California Supreme Court, and there are sort of two things that I think the court is going to look at. One is this fundamental question of, do these defenses to 226 and 203 apply to meal period premiums? And two is this footnote that the California Court of Appeal gave us that says, yeah, and there would be a good faith dispute as to whether meal period premiums were owed timely at termination regardless, because before 2022, the California Supreme Court hadn't said that those were wages. And so everybody would have a good faith dispute that those were owed timely at termination. I don't know if the California Supreme Court is going to let us keep that one, but we'll find out. Next slide, please. With our last couple of minutes here, I want to do a brief discussion about rounding, because Camp versus Home Depot is a case that is before the California Supreme Court right now, and this has some potential significant impacts coming down the pipe this year, all right? So real quick, next slide, please, Brenda. Overview of time rounding. Time rounding, just generally, refers to the practice of rounding an employee's work time into a whole integer for purposes of paying wages. All time clocks round to a certain degree, right? Even if it's to the nearest second. Like nobody, or probably nobody, is paying employees for fractions of seconds worked. Most common practice is for people to pay employees to the minute. You clock in at 9:31, we start paying you at 9:31. But we do see other rounding systems that are employed to the nearest, for instance, tenth of an hour or the nearest quarter of an hour. So somebody punches in at 9:07, you see that time round down to 9 o'clock. They punch in at 9:08, you see that round up to 9:15, something like that. Historically, these were implemented because of the difficulty in capturing time to the minute. It is less defensible today for two reasons. One, technology. Two, this decision from 2018, Troyster, that said essentially that the federal de minimis doctrine does not apply in California. Next slide, please. Historically, neutral rounding practices have been okay in California and under federal law. Your federal statute is here on the slide, 29 CFR 785.48, and we have this relatively old in wage and hour terms case, See's Candy Shops from 2012, which incorporated the language of that federal regulation and basically said that rounding is okay as long as it is fair and neutral on its face and is not used in a manner that results over a period of time in a failure to compensate employees properly for all of the time that they have actually worked. Cases that have followed See's, it is worth knowing, don't necessarily require 50% neutrality across the board. We see a lot of expert analysis in this space about how rounding affects employees, shifts, work weeks, different metrics. We've got case law approving facially neutral rounding policies that favor employers in, for instance, like 51, 52% of instances. But why do we have all of this case law on rounding? Because it's a really good way to get sued. It is a litigation magnet. Also, real quick before we talk about camp, I know we're running low on time. I'm starting to go fast. Thanks everybody for hanging in. We do know that rounding meal periods is improper. That came from Donahue a couple of years ago. Next slide, please. So, camp versus Home Depot. Home Depot's time clock actually captured all time worked to the minute. But its policy, Home Depot's policy in this case, was to round employee time to the nearest quarter hour. This policy was neutral on its face. It rounded up, it rounded down. But plaintiff's camp lost more than 7 hours of work time under the policy over about a 5-year period. So the lower court, or the Court of Appeal, reversed the lower court's entry of summary judgment, which had been granted in favor of Home Depot, saying based on that loss of 7 hours to camp, there is a triable issue of material fact for resolution as to whether Home Depot actually paid employees for all hours worked. Camp specifically limited its holding and said, we are not addressing whether rounding flies in other contexts. We're not addressing whether an employer who doesn't have the ability to capture an employee's hours worked is required to do so. We're not addressing whether, a case where the time clock isn't actually capturing these minutes, we're not addressing whether that flies under See's Candy. But we are addressing this case that is in front of us with respect to Home Depot's practices where the time clock captured those minutes and Home Depot decided not to pay employees according to those minutes worked, decided to round the time despite having access to kind of the more accurate reflection. Woodworth is up here because it was in a similar procedural posture. Summary judgment was granted in favor of the employer, reversed by the Court of Appeal, petition for review granted by the Supreme Court. Woodworth wrote for purposes of expressing its agreement with camp. What is the guidance here? Stay tuned on this one. Keep an eye on what the California Supreme Court does here. But start to evaluate your rounding practices if you have not already done that. And know that California is getting stricter with respect to unpaid time. We are seeing more of this lines at the time clock, distant time clocks, bag checks, donning, doffing. California is getting stricter about unpaid employee time, and that is a trend to really pay attention to as things are moving forward. Brenda, let me get the CLE code in because we are now right at the hour. The CLE code is SS 5721. That is SS, like Seyfarth Shaw, 5721. I know it is exactly 1 o'clock. I see that there's a little comment or a little bubble in the Q&A, but I'm not sure that we have time to address any. But Chris, why don't I hand that back to you to wrap us up here.
Yes, thank you, everybody. Yeah, we are out of time. If you did submit a question, we'll try to get back to you via email. Also, if you would like to request a copy of our ebook, you can either try to click on this link here, but also we're going to be emailing people who participated, and that will provide you with a way to request our ebook as to the 23rd edition of Litigating California Wage and Hour Class and PAGA Actions. And thank you, everybody, and thanks to Michael and Bailey, and we will see you next year.